All rise. The Court of Appeals, Division 1, is now in session.
Thank you. Please be seated. Good morning. We're here in our case, Wednesday, CV140606, Hutchinson versus American Family. Each side will have 20 minutes for argument. Appellant, you may reserve any portion of that time for rebuttal, but you have to keep track of that time yourself. There's a clerk at the podium to do just that. And we will be recording this argument in a couple of days. It should be on YouTube, so you can watch and determine for yourself how you did. We've read the briefs and the record, and we've conferenced the case, so we're familiar with the case. So when you stand up to argue, just launch right into your argument. And if I missed this earlier, when you approach to do your argument, please identify yourself and your client. Counsel, you may begin.
Charles Onifrey from Schneider & Onifrey on behalf of Appellant Sharon Hutchinson. I'd like to reserve 2 minutes in rebuttal of my argument. As the court knows, the amendment that we had proposed was to add a bad faith claim, not based on failure to investigate, but on the notion that they had lowballed us, and at some point in time in the process realized they were lowballing us and just forced us to go through the arbitration process in hopes that she would walk away. The court disagreed with our claim that it accrued only after the arbitration award, said that it accrued much earlier, back in 2010, but that it related back, but that there was delay in bringing the claim. We think the court erred in at least 4 different ways. First, from our perspective, we don't see how the claim under our theory could accrue before the arbitration award. Again, we weren't arguing bad investigation. They dragged it out. They treated us, abused us. The claim was at some point you valued it, you knew it was worth a lot more, and you still made us go through the process. If the arbitrator had ruled, and even though you might think that the damages all along, or they're valuing it way low, we've all had those instances where, the arbitrator rules against you, the jury rules against you, and if the arbitrator ruled that the damages totaled $18,500 or less, we didn't have a claim. We just didn't. I don't know how I could have pursued a bad faith claim where my theory was they lowballed us and that the claim was worth much more when the arbitrator has determined that American Family was right. So from our perspective, I just don't know how the claim could accrue before that, because that defined the damage.
It doesn't really matter, though, if we agreed with the trial court that the claim related back in time. I mean, it's still saved by the statute of limitations, and the accrual issue is irrelevant. Correct.
And with that, let me jump then back to the issue of the court believing that there was prejudice and delay. Here's why there was no prejudice or delay. First of all, there's no other issue that is being held up and being impacted by this. The complaint that was filed was for breach of contract and for the UIN benefits. Quite frankly, as I read that, it's the same thing. They simply decided, they being the prior counsel, we're going to arbitrate that dispute. They didn't dismiss the lawsuit. It was sitting there, but there was no other claim that existed. Now, I can't vouch for why it remained open. I can surmise, but the fact is that Superior Court action stayed there. It wasn't dismissed. with the only issue that they raised being arbitrated. So the notion that something else was being delayed or being harmed simply is not correct.
There's nothing in the record to suggest that that American Family was expecting a release or satisfaction of judgment or dismissal of the case after the binding arbitration process was completed?
I'm not aware of anything, Your Honor. I'm only aware of information outside the record, but nothing in the record that I'm aware of that suggested American Family viewed that as the end of the proceedings. And maybe
Did American Family object on the grounds of prejudice?
well, at the trial court, they certainly objected on the grounds, primarily saying that it didn't relate back.
Yes.
But they also claimed that it was they were prejudiced.
Did they explain how and why?
No, there was no representation as to a specific piece of evidence that was lost, destroyed, or would be less effective from a plaintiff's perspective. Again, given the theory that we were pursuing, the evidence is the claim file and the claim handler. That's within their control. So they never offered an affidavit or offered even an explicit description of what aspect of the case they were harmed by because of the delay in bringing it forward.
Do you think that the trial court simply saw a situation where the underlying accident was, what, 2007, and now it's 2014, and it's simply too old?
Well, for some reason the court just thought, and I know the court made a comment that it may have even been a tactic. I don't know that the court intended it to impugn anyone, but yes, it was a long period of time between the accident and when this motion was brought. I can't represent to the court what happened in those 5 years before I was asked to take over the case after the arbitration. I just know that it took a while, so they let the 2 years, they let 3 years go by because there was a 3-year statute on the UIM claim. And when it became clear that they weren't going to reach an agreement on the UIM claim, then the complaint was filed in August of 2010. Then roughly 2 years, over 2 years to get it to the arbitration process. But my belief is that the trial court misconstrued the notion that something else was being harmed, that some other aspect of the case existed, and it would be improper to let it, be dragged down by adding a new claim now. There wasn't anything left. It was simply the bad faith claim. And I don't believe the court was referring to the 8 months between the arbitration award in December of 2012 and the motion to amend being filed in August 2013. And then as a practical matter, I don't know, again, given our claim and our theory, how, even if the amendment had been proposed much earlier before the arbitration process, that you do this simultaneously. Because at the end of the day, it depends on the arbitration award. I certainly doubt that American Family was going to open up its reserves as part of its entire claim file, including its reserves, which would be relevant in a bad faith action, when you have at issue what is the value of the claim, which is the underlying breach of contract action. They wouldn't have been on the same track if only for the reason that the contract claim was agreed to be arbitrated. The bad faith claim, I certainly have no reason to think that they would have agreed to arbitrate the bad faith claim. So you would have had different venues as well. Everything about that indicates that even if the motion to amend were brought sooner, it would have been put to the side until the arbitration went forward with the result. And who could argue with the rationale if they said, Mr. Onifrey, what if the arbitrator rules the damages are less than $18,500? Do you have a claim? The answer is no, we don't have a claim, because they will have been validated. They were right to lowball us. We were wrong on the assessment. That's the reason why the arbitration award is so important. In terms of the trial court reaching the conclusion that The claim accrued in May of 2010 because of the denial letter. From our perspective, there's nothing about that letter that would tell you that they are not going to talk to you, they're not going to assess anything else left in the case. It simply says, they're reoffering. Says this will acknowledge receipt of your fax correspondence of May 5, 2010. We previously offered to settle Sharon Hutchinson's UIM claim in January 2009 for $3,500. The offer still remains the same. Please advise and I can forward our final release form for completion, period, end quote. I don't think any litigator, trial lawyer views that as they will never listen to anything we have to say again. And the reality is the claim did evolve over time. The first two demands back in 2008 and 2010 were largely the same, and as a defense attorney I could pick apart those demands in a number of ways that would legitimize American Family's position. But then in August 2012, Mr. Clark, then counsel, sent another demand, laid out the case in more detail, and for the first time brought out that there had been a diagnosis of fibromyalgia. Well, why is that important? As a defense attorney, when you look at those first two demands, what you see are gaps in treatment, delayed onset of symptoms, and migrating symptoms. That's not a sprain or strain. That's what they were looking at. That's what they thought. And then in August 2012, it is brought out that there's a diagnosis of fibromyalgia, which makes it, explainable, quite frankly. I think that any plaintiff in a first-party claim is entitled to believe that the insurance company, when presented with new information, will consider it. I think any seasoned litigator, when they saw that August 2012 demand, would believe American Family will increase its offer because the facts are different. The specials were higher, the past wage loss was higher, the future wage loss was higher. But it had made more sense because of the fibromyalgia diagnosis. So that is why that May 6th letter we don't think is a definitive denial, nor should it be interpreted as one. The fact is we don't know what the claims handler was thinking when they may have been sitting on additional money. They just weren't going to offer it at the time, at that time, given the demand of the case. In terms of the court believing the complaint that's filed in August 2010, alleged facts sufficient for the claim to accrue, the mere allegation that American Family had made an unreasonably low offer is only part of what a bad faith claim would require. Most notably, it's not just the denial of the claim, it's not just that it's without a reasonable basis, it's that the insurer knows or should know that what they're doing is wrong. We don't know what they know at what point in time. And the most important fact relating to that is originally they had Dr. Harry Tam, a neurologist who does an IME, issues a report supportive of the defense. Well, apparently at the arbitration he testified, and the arbitrator goes out of his way to talk about the significance of the fibromyalgia in his decision, and that Dr. Tam now could no longer refute what the plaintiff's doctors were saying. We don't know when American Family came to the realization that they no longer had a doctor to support their defense. If they had a doctor that walked in that arbitration saying she is making this thing all up, those symptoms make no sense at all, they would have had, whether the arbitrator would have agreed with it or not, they would have had a witness to contest it. It's only when we get to the arbitration do we realize they don't have a witness, because Dr. Tam is not going to stand behind his IME report. And then lastly, and then I'll sit down, in our view, there has to at least be a fact question as to at least one of the elements, again, that is what the insurer knew, what its state of mind was. Not just that it was lowballing us, did it know it was lowballing us? For all we know, Dr. Tam called up defense counsel the day before the arbitration, said, you know that IME report I was so strong on? I'm not going to back it up. Well, That's when they knew, oh boy, we don't have a defense to the case. Maybe he told them that months earlier, but we're never going to know that, or we didn't know that until we got to the arbitration where he couldn't back it up. So I think any prudent practitioner would have waited until the award was decided. It just makes sense under the circumstances. Unless the panel has any questions, I'm completed.
No.
Thank you.
Counsel. Counsel?
Good morning. My name is Lynn Allen of the law firm Tyson and Mendez, and I represent the Applee American Family Mutual Insurance Company. There are two reasons why this court should affirm the ruling of the trial court. The first and most compelling reason is that the trial court did not abuse its discretion in denying the motion to amend based on undue delay and prejudice. The second reason is that the trial court correctly found that the bad faith claim accrued at the latest on August 20th of 2010, but that the trial court incorrectly related the amendment back to the original complaint. I'm going to focus first on the trial court properly exercising its discretion by denying the motion to amend based on undue delay and prejudice. The trial court did issue.
Did your client object to the trial court on the basis of prejudice? And what was that prejudice?
Yes, Your Honor. American Family did object on the basis of prejudice, and I direct your attention to the index of record number 62, which is the transcript of the oral argument on the motion to amend, and we went into great detail as to the prejudice.
And what is the prejudice?
The prejudice to American Family is that the original accident was in 2007. The plaintiff made her claim to American Family for UIM benefits in 2008. And then there's a period of nearly 5 years that passes before she attempts to bring a bad faith claim. So the prejudice to American Family is first that the claim is stale. Witnesses do lose their memory over time. And none of the cases that we cited to the court actually required the defendant, the person opposing the motion to amend, to come forward with affidavits showing that witnesses had lost their memory. Well, it was presumed by those courts that when you bring a stale claim, especially one as old as this, people are going to lose their memories, evidence will be lost, and there's prejudice to the party defending the claim.
Well, counsel, putting aside your interpretation of that case law, did American Family put anything in the record in the form of sworn testimony, statements, anything to suggest that any evidence related to a bad faith claim was lost due to the passage of time, number one, or two, that any potential witness involved in a bad faith claim on the claim side from American Family or otherwise now is not available, or their memory is such that that they can't testify? Is there anything like that?
No, there were no affidavits presented to the court. However, this argument did develop during the oral argument, as you can tell from the transcript. So we didn't have an opportunity to present that evidence. And notably, the plaintiff did not raise any argument at the trial court level that the avowals of counsel, that the arguments of counsel, that based on the time of the delay, would necessarily lead to memories being lost or compromised by the passage of time.
Okay, well then let me ask it this way, because I'll have to go back and reread the transcript. In the avowals of counsel, was there any avowal that any evidence was lost relevant to the bad faith claim was lost due to the passage of time, or that any potential witness whose testimony might be relevant to a bad faith claim now could no longer remember or was unavailable?
No, there was no specific avowal as to specific individuals or pieces of evidence. Our argument was, just based on the general perception in the Court of Appeals, or I'm sorry, the appellate court cases, that the passage of time does in fact compromise memory. And I think that's probably a principle that's well received in the law. I'm thinking to the jury instructions that are given, talking about credibility of witnesses, and one of the things that the jury can consider is the passage of time and how that affects memory. So no, we did not present specific evidence. The plaintiff never objected to the fact that we didn't present specific evidence, and they could have and would have had an opportunity, if they thought that was an issue, to file a motion for reconsideration, thus prompting this. And again, I bring up the fact that this argument and this issue was really raised by the trial judge during our hearing, so we were reacting somewhat in the moment on the arguments, and didn't have an opportunity to really present the judge with specific evidence. The prejudice is not just that documents could be lost or witness memories are compromised by the passage of time. The prejudice is also in the fact that we had an agreement. There were two claims that were made in the complaint: a claim for UIM benefits and a claim for breach of contract. American Family agreed to forego its right to a jury trial and to have the UIM claim decided by a single arbitrator. And the plaintiff agreed, and that's in an attachment to our response to the motion to amend, record number 33, that the plaintiff would not pursue the breach of contract claim. At no time had plaintiff ever hinted, and there's nothing in the record that the plaintiff ever hinted that a bad faith claim would be filed or could be filed after the resolution of the only claims in the lawsuit. And so the prejudice to American Family is that it made an agreement to forego its right to a jury trial on the UIM claim, and now they're trying to bring in, 5 years after the fact, a bad faith claim.
Was the payment of the $50,000 after the arbitration award, when that was tendered to a plaintiff, was there a stipulation for dismissal of the lawsuit attached to that as a condition of payment?
No, not as a condition of the payment. As the court knows, American Family can attach conditions on payment of an undisputed insurance benefit. So there were communications. They are not part of the record, so the court probably is not interested in those communications. But the case was not dismissed. And I know that's something that the plaintiff likes to bring up, and the court seems to be concerned about. There was the plaintiff, having prevailed at the arbitration, could have brought a motion for an award of attorney's fees. And attorney's fees are available per a Court of Appeals decision in claims for UIM. Even if there's not a quote-unquote breach of the contract, it arises out of contract, they could have brought a claim for attorney's fees. That's one reason why this case was left open. If American Family had prevailed at arbitration, American Family could have brought an award of attorney's fees. So by leaving the case open, that allows the trial judge to make that award. There are a couple of other reasons why it's prudent to leave the case open. The plaintiff may want to file a petition or a motion to confirm the arbitration award so that it can be paid if for some reason the insurance company doesn't pay. The second reason would be if the insurance company feels there were irregularities in the arbitration of proceedings, it would have the ability under the arbitration statutes to bring a motion to set aside the arbitration award. So there are reasons other than this phantom bad faith claim why the complaint and why the case would not have been dismissed prior to. I think the record will reflect that when the plaintiff had moved, I think for a scheduling conference on March 11th of 2013, it's record number 22. That was when we were like, no, I think this case has to be dismissed. And it wasn't until August, and now this is 8 months after the arbitration award. And now I'm kind of switching over to the undue delay, the unexplainable delay. The appellant hasn't made any effort either at the trial court level or here in the opening brief or the reply brief to explain why she waited 8 months after the arbitration award to file a motion to amend the complaint.
Well, how is American Family harmed by that 8 months?
Again, that's 8 months that have gone by where there's uncertainty, where American Family believes that the entire claim has been resolved, where, again, witness memories are becoming, further along in time. And
so it's just a general picture. It's nothing specific about, we know what we've lost. It's just generally witnesses' memories are 8 months older at that point.
yes, and just the general notion that witness memories fade over time as opposed to specific affidavits. I wanted to talk about, the case law that discusses delay and undue prejudice, because we're, seeming to focus on just this notion of witness memories or evidence being lost. But there's prejudice to a claim hanging on over time, and that's the uncertainty to the defendant. There's value in having litigation against a defendant wrapped up within a reasonable period of time.
Didn't American Family agree to continuances in this matter before the arbitration? Maybe I missed that, but it seemed to me that there were requests to continue the case perhaps on the inactive calendar, or while the plaintiff was undergoing treatment, and the counsel for American Family acquiesced in that.
Well, American Family acquiesced because, clearly if the plaintiff is undergoing treatment, if we hadn't acquiesced, the court would have granted the motion. So
that's sort of an exception to this broad argument you're making about the passage of time being a presumptive prejudice, creating a prejudicial effect.
Well, that was within the motion to continue on the inactive calendar was brought less than a year after the lawsuit was filed. Certainly memories are fresher at that time, and we're talking about at that point in time there was no issue on liability, so we don't have to worry about the underlying tortfeasor losing her memory of how the accident occurred. What we're talking about, what are this plaintiff's damages?
And in the various responses that American Family made to these serial settlement demands as the plaintiff continued in her treatment, when there were responses made by American Family with different dollar amounts, in those responses, was it ever suggested that we weren't going to pay anything because this claim is now stale and we think, as a matter of law, we've been prejudiced?
No, but those responses were made in 2010, within 2 years of her making, or a year and a half of her making the claim to American Family. And again, we're talking about the only witnesses at that time being healthcare providers, and what her injuries were, what the treatment was, and how much it cost. So that's a far cry from what American Family is faced with in August of 2013. 5 years after the claim was opened, where a claims adjuster who has handled thousands of claims since that time is now being asked to remember how and why she made decisions in 2008, 2009, and 2010 when this claim was being adjusted.
You're not suggesting that there aren't claims notes that would assist the adjuster in remembering why decisions were made?
Well, there would be claim notes. How well this adjuster documented her reasonings would be an issue. They typically don't write a novel listing every reason why she thought the claim was worth $3,500 over the $15,000 already recovered. Memories are fresher, closer in time to actions, and sometimes recorded recollections aren't a good substitute for a good fresh memory. The case law that we've cited in our brief regarding courts of not abusing their discretion in denying a motion to amend, and that's what we're talking about here. It's not that this court substitutes its own judgment, looking at the evidence with your perspective at the appellate level. It's whether our trial judge abused his discretion in denying the motion to amend. And a lot of the cases, such as Owen and Bishop and the rest, they talk about these were motions to amend that were brought sometimes a couple months before trial, a few weeks before trial, or even a few days before trial. In this case, we had already had our trial. We had our arbitration. Every issue in the case, with the exception of attorney's fees to the prevailing party, had been decided by the arbitrator prior to the motion to amend, and had been decided 8 months before. And so this case is even more egregious than the facts that were found in Owen, Bishop, and the rest. The Owen case is interesting, and it draws a distinction between motions to amend to assert new theories based on the evidence already in the case, and motions to amend to bring in a new theory that will require additional discovery. Owen actually was two decisions. One part of the decision affirmed or reversed the trial court's decision, and that was based on the respondeat superior theory. In that case, you may recall, there had been a deposition of the truck driver who was alleged to have caused the accident, and that occurred within a couple of weeks of the close of discovery. And it was at that time that the plaintiff first learned that there were issues with the trucking company's logs, violations of ADOT regulations, and the like. And so it was 10 days after that deposition that the plaintiff filed their motion to amend. And they wanted to add these allegations to the respondeat superior theory that was already in the case, and they also wanted to add a claim of independent negligence against the trucking company. The Court of Appeals ruled that simply adding to the theory of respondeat superior that was already in the case, simply adding the notion of gross negligence and punitive damages based on facts that were already in the case, on a theory that was already in the case, that the trial court had abused its discretion. But as to the new claim that was being brought, the claim of independent negligence, the court found that the trial court did not abuse its discretion because it would require discovery. It would require delay of resolution of the case. And we have that here. There had been, because there was no bad faith claim brought, and because the breach of contract claim wasn't pursued, there'd been absolutely no discovery in this case regarding American Family's investigation of the case, evaluation of the case, its decision making. All of that would have had to have been done 5 years after the claim was made to American Family. And then I want to, because I don't have much time left, but I want to talk about the accrual issue, because that ties into the court's decision to deny amendment, because the court found that the bad faith claim should have been brought within 2 years of August 20th, 2010, which was when the complaint was filed in the underlying case. And the plaintiff really misconstrues what it means for a claim to accrue. A claim accrues, a tort claim accrues, not when the plaintiff knows all of the evidence and all of the damages that they might be entitled to. It accrues when they know or should have known that the elements of the claim exist. And the plaintiff knew this no later than August 20th of 2010. We believe May 6th of 2010, the earlier date, but it really doesn't matter in the context because the claim would have been untimely regardless. The May 6, 2010 letter in which American Family said, we'll pay you $3,500 was an unequivocal decision to offer that money. You may recall that an American Family had initially offered $2,500. The plaintiff came back with a letter making arguments. American Family said, okay, we'll pay you $3,500. Then the plaintiff submitted another demand and said, no, really, you should pay more than $3,500. And the May 6, 2010 letter was in response to that, and it stated, we are going to reiterate our offer of $3,500. That is what we're offering you. So that was when the claim, it wasn't denied, but that was when American Family made its claims decision and communicated its claims decision. And under the Ness case, that's all that's required to accrue a cause of action for bad faith in a first-party case. And
hasn't the Supreme Court suggested in the Walk versus Ring case that accrual of a cause of action is generally a question of fact?
It would be a question of fact if there is evidence supporting another accrual date, and that's not the case here. And there is a 2015 case, and it is out of the District of Arizona, but it does follow Ness. And I'm going to give you the citation because it was published after the briefing in this case. It's Thompson versus Property and Casualty Insurance Company of Hartford. It's 2015 Westlaw 1442795. And in that case, very similar to the facts we have here, there had been a letter from the insurance company making a definitive decision on a first-party claim, and Judge Teelberg held that under the Ness case, that definitive decision is what triggered the accrual of the bad faith claim, and that.
Counsel, were you following on the supplemental authority?
Yes, I will.
Thank you.
I'm sorry, I found the case last night as I was preparing for today. The argument that the UIM claim had to be resolved before the bad faith claim was filed is contrary to Arizona law. It's contrary to the law of the Arizona Supreme Court. There were a number of decisions, Deese, Rawlings, and I believe another one we cited that held that there does not have to be a breach of contract for a bad faith claim to exist, and that those claims can be brought simultaneously. And I wanted to point out in the Deese case, Deese rejected a case called Brown versus Superior Court, which suggested in a footnote that the bad faith claim had to be deferred until the point in time when the underlying first party claim was resolved. Deese said, no, that's not the law in Arizona. And this court should follow that. The UIM claim does not have to be resolved for the plaintiff to bring a bad faith claim. I would also point out that the Florida cases and I think a Texas case cited by the plaintiff for the proposition that the UIM claim must be resolved before a bad faith claim was based on a Florida statute that actually said you can't bring a bad faith claim until you resolve your UIM claim. And I believe I am out of time unless you have any additional questions. Thank you.
Counsel. Rebuttal, please.
Thank you, Your Honor. Counsel's statement that you don't need a breach of contract in order to have a bad faith claim, and generally speaking, it's true. But you can't tell me that every defense lawyer, if that arbitrator had ruled your damages are only $18,500, the very first motion you get is a motion to dismiss the bad faith claim because it doesn't exist. They were exonerated. They were ratified, and you made the right decision, American family. I just don't know how they don't have a response to that argument. In terms of the prejudice, the relevant time frame for them to claim prejudice is not going back to 2007. It's August of 2012 when Mr. Clark, who was the new counsel, writes the August 16, 2012 demand letter. That is materially different than the other two demand letters because it raises the diagnosis of fibromyalgia. That's important because that's the basis of the arbitrator's decision. And so within 1 year, the motion to amend is brought. And American Family did not, either at the trial court level or here, offer a single specific instance of how they might be prejudiced. The discussion of prejudice in the trial court in the transcript begins at page 20. I heard counsel refer to an avowal. There was no avowal made by counsel, nor was there anything specific talked about. It was just that it was delayed. In a matter of 1 year, the evidence that we need for the bad faith claim is the claim file and the questioning to the claim examiner, Mr. and Mrs. Claim Examiner, after you got Jim Clark's demand letter of August 16, 2012, Tell me how it is that you arrived at the conclusion that this case had a value of only an additional $3,000 or $3,500. That's the question. And what are they going to rely on? They have an arbitration memo where they put together a variety of arguments. You could rely on that. They've got their claim notes. One would highly surmise that it comes down to Dr. Tam was not there to testify for her. He was there. He just didn't back up his IME report. Now, when that happened, I don't know. But it could have happened a long time before that, but we didn't know it until we got to the arbitration. In terms of what actually was going on at the trial court, when the Superior Court action was left open, we just don't have a record to make any conclusion. What is not in the record, as the court mentioned, is no dismissal or stipulation to dismiss in the meantime, nor is there any release of all claims that probably would have been made part of the record if that had been the case. Again, the reasons for leaving it open are reasons that are unfortunately outside the record. I don't think the court can reach a conclusion as to that. So unless the panel has any further questions, I think I've presented what I like.
No, counsel, we appreciate both counsel's arguments, and we'll take this matter under advisement and issue a decision in due course.